Hospital practice is regarded as a business, indeed big corporate business, with an estimated expenditure of over $200 billion yearly in the United States, which represents approximately 1/10 of the gross national product. There are different types of hospitals. A general hospital treats all types of diseases versus a specialized hospital, which limits its scope of treatment, for example, to treating cancer, children, or women. A teaching hospital versus a non-teaching hospital is authorized to teach medical or dental students and or provide postgraduate training for interns, residents, and fellows. Then we have the government hospital, which is owned and operated by governmental agency and maybe a federal, state, county, or a city hospital. The government hospital is also referred to as a public hospital, and this is to be contracted with the private, non-governmental hospital, which may be owned and operated by an organization, such as a church, fraternity, or community. The private hospital may either be a tax-exempt non-profit corporation or a corporation providing care for its own employees. A few words about the Hill-Burton Act and hospital construction funds. There are federal funds provided under the Hill-Burton Act and administered through the United States Public Health Service Agency. The purpose is to encourage hospital construction and state in various parts. Such federal funds are given to hospitals, and the hospitals have to provide services for indigents. Therefore, if a federally funded hospital denies medical services to indigents, then the indigents may have a private action or right to sue a hospital under the Hill-Burton Act for refusal to admit them to the hospital. What about hospital licensing acts? Hospitals must comply with the Hospital Licensing Act, which deal, among other things, with administration and planning, medical staff and personnel, laboratory, radiology, emergency care, restorative and rehabilitative services, accommodation of patients, facilities and equipments for care of patients, records, report, food service, the physical plant itself, newborns, maternity, pharmacy, drugs, and other services, including other matters, administrative procedure, and due process. And then there is certification of need. A license for construction, addition, modification of a hospital requires a showing of need to the community and certification of need from a health systems agency, HSA. The HSA is the Health Planning and Resource Development Agency, designated under the terms of the National Health Planning and Resource Development Act of 1974. The latter public law requires the designation of Health Systems Agency in each of the health service areas in the United States. The Health Service Agency may be a non-profit private corporation, a public regional planning body, or single units of local government charged with performing the health planning and resource development function listed in the Act. The legal structure, size, composition, and operation of HSA is also specified in the Act. The operation of hospitals has become complex. Several hospital administrators are becoming the rule in major hospitals over 500 beds. Some hospital administrators are becoming so subspecialized. Specific areas of hospital practice are being assigned to various assistant administrators. Moreover, the complex legal aspects of hospital practice have driven some administrators holding administrative degrees to seek additional legal study and obtain a law degree. A hospital is generally a corporation and should have articles of incorporation, which should be filed properly with the Secretary of State. The hospital also has bylaws which deal with the composition of the governing board and the conduct and frequency of various meetings and committees, and the authority, privileges, and responsibilities of the governing board, and also the medical staff of that institution. In addition, the hospital has rules and regulations which deal with the conduct of hospital activities. And there are specific requirements imposed on the hospital governing body and medical staff by the Joint Commission on Hospital Accreditation, known as JCAH. The JCAH is a private, independent body comprising representatives from the American Hospital Association, the American Medical Association, the American College of Physicians, and the American College of Surgeons. The JCAH is a voluntary process and yet quasi-mandatory. Non-accreditation of a hospital will result in substantial loss of revenues plus state and federal programs. The standards of the Joint Commission on Accreditation of Hospitals spell out the responsibilities of the governing body and medical staff with regard to qualifications, experience, present capabilities, and the duty to review qualifications and performance of the medical staff, who will be regularly monitored to maintain a high professional standards of care. Provisional accreditation denotes a classification of a hospital which is allowed to operate as an accredited hospital, but must take certain substantial steps to comply with the JCAH mandates. Hospital accreditation is awarded for a term of less than 3 years by the Joint Commission on Accreditation of Hospitals. Accreditation of hospitals by the JCAH has become extremely important since the pronouncements by the Illinois Supreme Court in the case of Darling versus Charleston Community Memorial Hospital, which held that accreditation standards, along with the regulations under the Hospital Licensing Act and hospital bylaws, could be considered by a jury in determining whether a defendant hospital has observed the proper standards of care. The case of Darling has been cited in numerous other cases, as will be discussed subsequently, including Board of Trustees of Carson versus Tahoe Hospital and Gonzalez versus Nork and Mercy Hospitals of Sacramento, both of which held that a hospital may be corporately responsible for the conduct of its medical staff. Question: what happens to the application form of a physician who would like to obtain privileges at a private hospital? In general, the physician is armed with a medical degree, a license to practice in a state, perhaps residency and fellowship training, eligibility for or actual board certification in a specialty and possibly a subspecialty, and now the physician has to apply for consideration for a privilege to practice in a certain hospital in the state in which he or she wants to practice. Upon completion of the application for staff privileges by the physician, the application form is reviewed for completion by the medical staff secretary, after which the Credentials Committee determines the qualifications of each applicant. The Credentials Committee is also responsible for making evaluations and recommendations concerning reappointment, promotions, demotions, and withdrawal of privileges by the staff physician. The Credentials Committee is composed of representatives of the major specialties and is able to review medical records, reports of other committees, or breaches of ethics by the applicant or the staff physician. The Credentials Committee reports its findings and recommendations regarding a physician applicant to higher authorities. Final approval to grant privileges to practice in a hospital rests with the governing board. Now, the hospital administrative and governing boards have the right to provide for the management of hospitals, generally as corporations. More recently, the courts or judges have imposed on the hospitals what is known as a common law duty requiring the hospital governing bodies to maintain a system of continuing review of qualifications and performance of hospital staff physicians. Among the recent case law or judge-made law dealing with the common law duty are the following. In the 1965 case of Darling versus Charleston Community Memorial Hospital, which was cited earlier, the hospital governing body had a duty to establish mechanisms to evaluate the quality of patient care by the medical staff, and the hospital has to take action to avoid an unreasonable risk of harms to one of its patients arising from the treatment rendered by the medical staff physician. In the case of Darling, the common law duty of hospitals is to see that its employees observe the condition of the patient and report their findings to a higher authority, thereby limiting the common law duty to mere monitoring of performance of the medical staff physicians. That was in Illinois. In the case of Fiorentino versus Wenger, a 1967 case from New York, the court held that if a hospital could be liable for malpractice of an independent contractor physician practitioner if there was reason to know that malpractice would occur. Then there is the trial level decision of Gonzalez versus Newark and Mercy Hospitals of Sacramento, a California case in 1973. It incorporated some of the reasoning of the Darling and Fiorentino cases and held that a hospital had a duty to create a mechanism by which it may discover the inadequacies of staff members and a further duty to act to prevent harm to patients when poor performance is noted. This seems to be the trend in most recent cases. Therefore, if there is proof of failure on the part of the hospital governing bodies to provide a system by which information could be obtained pertaining to the quality of the medical staff physician's performance, and if there is also proof of failure to investigate possible problems in medical staff performance when the hospital became aware of them, there lies hospital liability predicated on negligence. Since the case of Darling in 1965, a number of other cases have dealt with the common law duty of hospitals to monitor medical staff performance. In the case of Purcell versus Zimbelman, a 1972 case from Arizona, the surgery department failed to take action against a surgeon whose lack of skill should have been apparent. Also in 1972, a case from Georgia, Mitchell County Hospital Authority versus Joyner. There the court held that the delegation of authority by the hospital governing body to the medical staff to screen applicants did not relieve the hospital of liability, since the medical staff was acting as an agent and the principal was the hospital through its governing body. Another case from Missouri, a 1972 case, Gridley versus Johnson. It was held that a hospital would be liable if it allowed members of its medical staff to violate its standards. And in the case of Corletto versus Shore Memorial Hospital from New Jersey, a 1975 case, the court refused to dismiss complaints of alleged negligence on the part of the surgeon, the hospital, the governing body, the administrator, and all the medical staff of that hospital on the basis of public policy. The employer of an independent contractor physician may be held liable if it knew that the independent contractor was incompetent, and hence the hospital governing body and medical staff had a duty to admit only qualified physicians to practice in the hospital and to withdraw the privileges of any physician who appears to be unable to perform adequately. In addition to judge-made case law, there is also statutory authority by state and federal statutes placing responsibility on the hospital governing body to see to it that physicians are organized in such a manner as to effectively review medical staff performance in an effort to reduce morbidity and mortality and improve hospital care of patients. The hospital governing body is permitted to delegate authority to medical staff to monitor quality of health care and review physician performance. Such statutes can be found in Michigan, Florida, Oklahoma, and federal statutes. It is therefore apparent that the law has placed increasing responsibilities on hospitals for credentialing and on peer review committees concerning performance of physicians. In order to protect physicians sitting on peer review committees who are settling or reviewing standards of medical credentialing of physicians and evaluating patient care and hospital services, state statutes have granted immunity to the peer review process. The statutes have afforded an absolute privileges to proceedings and records of such review committees from discovery or introduction into evidence in any civil action. However, such immunity to peer review committees and protection of records is accorded if such committee members act without malice and such action or recommendation is warranted by the facts known to them after a reasonable effort to obtain said facts. One must also remember that while committee peer review actions and accreditation proceedings are protected by law, committee members may still be sued for defamation or interference with the practice of a physician if it can be shown that derogatory statements were made about a physician outside the peer review and credentialing process, or if any non-privileged action was taken against a physician which may curtail his or her practice. As noted earlier, the principle in the case of Darling states that the hospital may be legally responsible for injuries caused by medical staff physicians if the medical staff did not conduct adequate peer review. In a 1982 case from California, Elam versus College Park Hospital, a woman sued her podiatrist for having performed unsatisfactory surgery on her foot. It so happened that her attorney was representing 3 other patients who were suing the same podiatrist, and the hospital was on notice of one of those suits approximately 4.5 months prior to the surgery on Mrs. Elam. But the medical staff did not investigate the facts of that lawsuit to determine whether they might have warranted withdrawal of the surgical privileges of the podiatrist. The Elam case is similar to the 1972 Arizona case of Purcell versus Zimbelman, where a surgeon got into trouble by performing surgery on the colon. That surgeon had been previously sued twice for complications arising from the same type of colon surgery, but neither suit had been considered by the medical staff peer review committee. The question was whether such a review would have led the committee to alter the privileges of that physician before the operation on Purcell. Therefore, the cases of Elam and Purcell involve the evaluation of evidence known to the hospital that may have a bearing on a physician's conduct in the hospital. There is no issue here with regard to the hospital's medical staff peer review records, which are protected by confidentiality statutes in both Arizona and California. What the courts are saying is that the cases such as Elam and Purcell will be tried in court, and the jury will become members of the Credentials Committee and will hear evidence concerning the conduct of the defendants in the previous suits that were brought against them. Furthermore, an expert witness testifying for the plaintiff will be asked if such evidence should have led the Credentials Committee to restrict the defendant's privileges for the procedure in question. If the expert witness says the evidence was sufficient for loss of privileges, then the jury may accept the conclusion and find the hospital legally liable for the committee's failure to consider that evidence. In closing, I would like to quote from an article by a physician attorney, Dorothy Rosinski Gregory, who said, and I quote, "With increasingly heavy burden on medicine to keep its own house clean, one may ask how this can be accomplished in the context of today's modern American hospital, which demands cooperation, integration, and reciprocal collaboration among several diverse groups of staff and healthcare providers. How can one maintain good staff relationships while still scrupulously overseeing a high level of care and maintaining such a degree of intra-professional rapport to ensure the patient of the highest quality of medicine and surgical care? Will Big Brother constantly be watching over our shoulders? Obviously, an extremely high degree of professional maturity, integrity, and objectivity, to say nothing of certain legal protections, will be required. What this means is that the Credentials Committee must consider an additional piece of evidence in its evaluation of the credentials and privileges of hospital staff physicians. If it fails to do so, at least in a couple of states, the hospital will assume liability if in fact such evidence should have led the committee to take action against a staff physician. Peer review should obtain reports on and raise questions about the capability and competency, be it physical, mental, or emotional, of their fellow peers with whom they practice. And they also should weed out the incompetent and ineffective practitioners. At the same time, the reviewing peers should avoid statements made negligently or prompted by malice or ill will.